constitutional provisions and disrupt the delicate balance between fairness, accountability, and prompt resolution of serious matters. My Lord, once the proceedings commenced, they not only assumed a judicial, they were not only proceedings of judicial nature, but had political ramifications, my lords. So that learned friends have submitted or are submitting as though these were normal proceedings. But Lord, these are the proceedings touching on the impeachment of a deputy president of the Republic of Kenya. And therefore, my Lord, several issues, including delicate issues of national security, national safety, and several issues, areas of accountability, my Lord, were on trial. The petitioner, therefore, ought not to be accorded an opportunity to challenge proceedings that he opted out of. My Lord, this is the point, my Lord, that the standing orders gave timelines for appearance and the reading of charges that occurred on the 9th. It took another 8 days for the trial to convene on the 16th and the 17th. The petitioner had sufficient time between the 9th and the 16th to file pleadings. And my Lord, he had the best of counsel in this republic. His legal team was led by none other than Paul Mwita, senior counsel, a seasoned senior counsel, and Mr. Ongoya, senior counsel, and other counsels sitting here, including Mr. Macharia, my Lord. He had the crème de la crème, and cannot claim, my Lord, that he was never afforded an opportunity to be heard. My Lord, the Supreme Court in the Sonko case has warned against delays in proceedings, because what is complained of here, my Lord, is that the processes of impeachment and the hearing leading to the impeachment of Rigathi Gachagua was undertaken with God's speed. Or as my learned friend Mr. Macharia said, with goon speed.
No, he said ungodly speed.
Well, it is with godly speed, my Lord, because the Senate, my Lord, the Speaker, gazetted 10 days within which to hear, to conclude the proceedings, my Lord. My Lord, within that time, pleadings were filed by all parties, and all parties appeared during the hearing. My Lord, in the Sonko case, this is what the court stated, my Lord. While on this question, it is important to observe that the multi-stage nature of the process of removal from office and the attendant litigation that follows have produced in the recent years a worrying trend that, in our view, amounts to abuse of court process by parties. Parties employ all delaying tactics in the book to avoid the consequences of the lustration provisions, chapter 6 of the Constitution, that disqualifies an individual from holding a state office, and so on and so forth. My Lord, the court addressed the question of the timer's conclusion of proceedings. My Lord, it is not true that the petitioner was not allowed to participate in the proceedings before Senate. Indeed, he fully participated. He sat through the proceedings. And my Lord, let me just demonstrate what he did, my Lord. My Lord, the petitioner made an opening statement through his advocate, who was none other than the eminent senior counsel, Elisha Ongoya. Secondly, my Lord, he was granted an opportunity to cross-examine witnesses of the National Assembly, including the mover of the motion, One Honorable Ekomas Mwengi Mutuse. He cross-examined Mutuse, my lord. He also filed his response to the particulars of all the allegations before Senate, and in respect of all charges. Fourth, my lord, the petitioner filed a witness affidavit sworn on 12th October 2024, and a further witness affidavit sworn on 13th October 2024, which were in volumes, my lord. And lastly, he filed indices and a bundle of documentary exhibits together with video evidence in support of his case. My lord, this will become important in the end and will demonstrate or will show why certain charges failed, because not all charges were proved against the petitioner. He had excellent counsel prosecuting his case and defending him before Senate. My lord, why then did Senate decline the prayer for adjournment? My lord, this part of my submission is interconnected with the response that shall be submitted upon, my lord, by my learned friend, Mr. Mukele. But my lord, we'll go to show that every opportunity was afforded to Paul Mwite Senior Counsel and the petitioner at the time to conclude the hearing. My lord, on 17th October 2024, Senate concluded the hearing of the National Assembly's case at 1:15 p.m. The petitioner, the Deputy President then, Rigathi Gachagua, sat through all the proceedings and was all smiles in court. At 1:15, my lord, the Speaker directed that upon resumption of Senate hearing at 2:30, the Senate would hear the Deputy President, Rigathi Gachagua, for 2 hours. The 2 hours that you've given us today, my lord. My lord, when the House convened at 2:30 p.m., and this is all in the affidavit, my lord, of Jeremiah Nyegenye, sworn on 21st October 2024. When Senate resumed at 2:30, my lords, counsel for the petitioner, Mr. Paul Mwite Senior Counsel, sought time to establish the whereabouts of his client, whom he had walked out of court at 1:15, my lord. He walked him out, and then he suddenly disappeared into thin air. And when he came back, my lord, at 2:30, he told Senate that his client was no longer visible